just move my little thing out of the way. So I think I've got the date right, hopefully. Okay, so what are we talking about today? Today, I'm going back just to have I did mention to you, I think beginning of the year, about expert witness immunity, which is obviously a good thing for you guys, the guys that do your reports. I thought there was a recent Supreme Court case which gave it the thumbs up again, and in fact probably extended it a little bit further than it currently is. So I thought it would be a good idea just to revisit it and remind you guys of the fact that it exists. So hopefully put some fears to rest, but also just what it covers. So we'll start with a quick recap. So this idea that expert witnesses shouldn't be able to be sued either by their own clients or by the other side, it's been around for a long time. None of you guys look 400 years old, but it has been around. And it's all about what would happen if you didn't have immunity. Then who's going to give evidence as an expert in a matter they're just getting paid their fees? You wouldn't be able to get insurance for it. It would be a disaster. So the idea is that you're able to get immunity so that we are able to get expert advice and evidence in court cases. Of course, our friends in the UK, they do some things in a funny way, we think. And since 2011, they got rid of the immunity. They said that it's all theory, that the most likely consequence of getting rid of that immunity would be that you'd need to watch your P's and Q's, and that you would be more careful about being independent and do your job thoroughly to avoid the risk of embarrassment, let alone being sued. Well, in Australia, we haven't taken the same view, and the rationale for it is it's not really about those people, those experts who do their job well. It's about the unjustified and vexatious claim that disgruntled litigants might bring. And we've all had, whether we're lawyers or we're experts, had clients who want you to be a yes person and just say things that they want you to say and not take an independent view. And if you do take an independent view, well, then they can get a bit narky about it. So this is all about making sure that isn't a pigeon that comes home to roost, as it were. And so basically the principle is you've got an absolute immunity from any claim relating to the evidence, not only the evidence you give in court, but also the contents of a report that you adopt as your evidence, which is fine, and is fairly clear, I suppose, where you prepare a report, the report's filed and served, and you go in and you give evidence in the tribunal or in the court. It doesn't cover everything, though. So usually work done outside the court, which doesn't affect the conduct of the case, and that's the important qualification, isn't covered by the immunity. And if you really do the wrong thing and you're the subject of disciplinary proceedings, well, the immunity doesn't cover that. So you can still be disciplined by a professional body, or we all know we give an oath or an affirmation, and if it's shown that you've breached your oath or affirmation because you've given evidence that is untrue, then you might be subject to a prosecution for contempt of court. And as I've said previously, prevention is better than cure. So the idea is to make sure you do whatever you can to avoid giving a client the opportunity to sue you, because it's time-consuming, expensive, and all the rest. Having said that, let's have a look at this recent case. So this is the case of Haspel and Parmigiani. Sounds a bit like the people's favourite favourite meal at an RSL or a club, the chicken palmy. I don't think it actually involved that. And it was slightly outside the scope of what you guys do. So this was about a medico-legal expert, and I'm sure you'll be amused. The case was about a solicitor who'd been certified unfit for his employment because he claimed of depression and anxiety. His employment was terminated by his solicitor employer, and he said, well, look, what they're saying, the reason for my incompetence is because they've been bullying me and they've been discriminating against me and they've been harassing me, and this has led to depression and anxiety. So I want to bring a claim against my former employer who has sacked me. So they lodged a complaint with the AHRC, the Australian Human Rights Commission, and appointed an expert psychiatrist to medically assess the plaintiff client and provide an expert opinion by way of a written report. So the client went along, the former solicitor went along to an assessment. The medico-legal expert provided a medico-legal report in the usual form with the acknowledgement that it's part of the expert, had to comply with the expert witness code of conduct and all the rest, and provided this report. Now, the report concluded that the client's condition existed before his employment. True it was that it's likely to have been exacerbated by the way in which his employer responded, but nonetheless, the symptom that the condition existed before his employment. The client didn't like this. The client wanted to say it was all his employer's fault, and as a result of that, because he didn't get a good report out of his expert, he abandoned his Human Rights Commission claim against his former employer. So what did he do then? He then, because he didn't like the report, he started proceedings against the medico-legal expert. And what he said was that the expert immunity required that the expert not only prepare the report, but he also had to give evidence, not just the report. And remember, in this case, the report wasn't even served. So the other side didn't get to see the report because they abandoned the proceedings. But the thing is, and what he tried to say was, look, what he was really doing was giving me advice about whether I had a case or not. It wasn't really to be part of the case. So that was what he put to the Supreme Court. The Supreme Court said, no, that's not right. He was retained, as in the expert was retained, to examine the plaintiff and prepare a report and give evidence as an expert witness in court proceedings should it be necessary. It wasn't just a consultation. It was all about a report to be given in court and evidence to be given in court, even though it wasn't served and it wasn't actually used in court. So all you need is that the evidence might be used in court, that's the purpose. And in saying that, the Supreme Court said, just because you get an opinion that's not favourable, and any decision of the client to use the report, that's not relevant. What's relevant is that the report was prepared in the context of either actual or foreshadowed legal proceedings for the purpose of use in those proceedings. And if you can fit into that, then you fit into your protection from being sued by your client or the other side's client. So, as I say, it's probably expanded it a little bit, made it a bit clearer, and most importantly, reaffirmed that we're not going to follow what they do in the UK, which is usually a good thing, I suspect. So that's that. Any questions?
Dave,